District is now in session. All those with cause, please draw an eye, give attention, and shall be heard. May God save these United States. The great state of Florida and this honorable court.
Be seated, please. Good afternoon, ladies and gentlemen. What we're going to do today is take the cases in the order that they appear on the docket, but we would be breaking for coffee after the first case, and we would invite all of you to come and have coffee with us. We'll be doing it on the third floor in the rotunda. And then after the second case, we're going to take another break to swap out the panel. So case break. And we'll call the first case, Thornton versus State of Florida.
Good afternoon, Your Honors. May it please the Court, my name is Dean LaBeouf, and I represent the appellant Sabra Thornton. I'd like to reserve 3 minutes of my time for rebuttal. The trial court erred in denying the defendant's motion for a judgment of acquittal in this case. The defendant was charged with 6 counts of theft, which were all specific intent crimes. The state not only failed to prove that the defendant had the criminal intent to steal, the state also filed a third motion in limine preventing the defendant from arguing her lack of intent to steal.
Well, didn't the judge say you couldn't argue criminal intent?
Well, in her statement, she said you couldn't argue criminal intent, but then it went on and talked about criminal intent, and the defendant was precluded by this order from fully developing what this court has clearly established in the Bartlett case as the requirement that the state prove the criminal intent to steal under Chapter 812.
Why isn't it a reasonable inference when the sheriff gave her the $40,000 that was somehow inappropriate, somehow wrong? Obviously, it wasn't her money. Why can't the jury infer it really wasn't the sheriff's money either?
Well, Judge, I don't think that the jury was entitled to make that inference, and the only evidence in this case really came from the sheriff, who said that he specifically told the defendant that it was his money from his own personal funds from which he secured the cashier's check, and that he concealed the fact from her that it was actually stolen funds that he had obtained through a kickback. That kind of inference, I think, is impermissible in this case to convict her of the intent to steal. In addition, she had put on a reasonable hypothesis of innocence by stating that she felt that she was wrongfully terminated. She told the sheriff that she had been wrongfully terminated and that it had devastated her life, and that as a result she had run up this $30,000 in credit card bills. And he said, "Don't worry about it, I'll take care of it, and I'll get the money from my accounts and give you the money."
But if we look at the totality, all the evidence, I mean, we have, I guess she testified that she slept with him once, that there was the 3-month severance package, and then she was rehired at the end of the severance period of time, but she never reported back to the sheriff's department. She wasn't put back on the agency phone list. She really never had any real duties assigned to her, I guess, through February anyways, I guess. Why not, when looking at all of that, the pay, I guess it was a monogram bathrobe, why couldn't the jury assume that, in fact, she was getting stuff that she wasn't entitled to, and she should have known that she was getting stuff she wasn't entitled to?
Well, Judge, it's our first position that we don't even get to the jury, that the state failed to establish the intent to steal. Remember, in this case, the defendant took the position that she was wrongfully terminated. She told the sheriff, and he hired her back. As a constitutional officer under 30.53, he had the absolute authority, and she had every reason to believe he had the absolute authority to hire her. He had control over who he hired, what the salaries were, and what equipment he provided. That's the information she has, that this is the sheriff, he has the right to rehire me. I told him that I was wrongfully terminated. He defines my job description. Although the state goes on and on about him saying that she didn't do any work from the time of her rehire until the time he was arrested, the state glosses over the fact that in the record at page 480, the sheriff said that Ms. Thornton never refused any of the assignments after her rehire. She went to a meeting that he asked her to attend. She went on the conferences that he told her to attend, and she was preparing for the legislative session. I think the evidence is clear, at least from her mind.
Does it ever get to the point, I mean, does she ever have so few duties for so long a period of time that she knows that, in fact, she is stealing? Especially, there was the romantic kiss it was described as. There was the exuberant hug, I guess. Does it ever get to the point where the jury can say, okay, you did so little for so long that you knew you were stealing?
That is, I'm sure, a possibility. But it doesn't match the facts of this case. There are plenty of lobbyists who live in this community who go for months without having anything to do, and then when the legislature's in session, they work over 100 hours a week. That was Ms. Thornton's anticipation. She was told, and it's unrefuted, that the sheriff said, I want you to stay in Tallahassee to be my legislative liaison, and you're going to be our representative because I'm the president of the Florida Sheriff's Association. And it was unrefuted that several prior sheriffs who had been president of the Sheriff's Association had moved employees to Tallahassee to be their liaison during the legislative session. Her position was terminated just 2 days before the session. So we've got her being rehired sometime in December. She's clearly qualified for the position. She felt that she was unreasonably terminated, and she was ready, willing, and able to do what she was told to do. And the unrefuted evidence in this case is the sheriff testified, I had the right to hire her, I had the right to define her job duties and specifications, and she never refused to do any official task. You can't charge her with theft because she didn't do enough, especially when her main assignment was coming up and she was relieved of this position just 2 days before the session started.
Mr. LaBeouf, what do you do with Sheriff Spooner's testimony that she had indicated to Sheriff Spooner once she had already been rehired by Sheriff Morris when she saw him at the Pat Thomas Academy that she had no intention of leaving Tallahassee? Her children preferred to live in Tallahassee. Why isn't that evidence consistent with all the other evidence that she, in fact, had no intention of going to Okaloosa County? And why is that not consistent with the state's position that this was all a ruse for her to temporarily remain in Tallahassee as Sheriff Morris's mistress?
Well, Your Honor, the evidence in the case went back and forth with regard to where she was going to be placed and when she was going to be placed. There was a lot of testimony, confusing testimony, with regard to housing, specifically with regard to the sheriff's testimony on her reemployment. He wasn't sure exactly when that conference at Pat Thomas Academy had occurred. She was working for the Pat Thomas Academy like several other deputies were doing. They had side jobs that were allowed to do that. I don't think that that testimony in and of itself is sufficient to overcome her hypothesis of innocence, that she had applied to be rehired because she was wrongfully terminated, and she was rehired. She was getting checks from the Okaloosa County Sheriff's Office in the position that the sheriff gave her. And she was basically an employee at will to do what he directed her to do in terms of her employment.
Well, let's talk. I'm sorry.
Counsel, in your brief, you didn't mention that the evidence is viewed in a light most favorable to the state and all reasonable inferences are taken in the state's favor. So I'm going to ask you to I'll do this with the state also. Give me the evidence you see in a light most favorable to the state, the critical evidence against your client in a light most favorable to the state, and tell us why that is insufficient as a matter of law. In other words, looking at this evidence in a light most favorable to your opponent, why is it still, what is it, and why is it insufficient as a matter of law?
Well, I think Judge Hawks hit on it when he said the evidence was, and the state cited it repeatedly, that the sheriff said from the time of her rehire to the time of my arrest, she didn't do any work for the citizens of Okaloosa County. That, I think, is the evidence in the light most favorable to the state. The reason we contend that it's insufficient is because in context, she was told that she was going to be the legislative liaison, and her job was to serve the sheriff in his capacity as president of the Florida Sheriff's Association.
Well, wasn't her title, as I recall, in that rehire slot, Assistant Director of
Support Services?
Support Services. That doesn't detract from your argument that the understanding was she was going to do legislative work?
I don't believe that there was real evidence in the trial with regard to the specific job descriptions of the specific title. Once again, under 30.53, the sheriff had the absolute authority to hire and to provide salaries and to provide job descriptions. Whatever her title was irrelevant to the fact that he gave her specific assignments, told her she was to stay in Tallahassee to serve as a legislative liaison, and it was her intent to do that, and there was no evidence to rebut that.
And so your contention is his comment, his statement on the stand that she didn't do anything, in context was essentially, I didn't ask her to do anything.
Not only that, but also when viewed with his other testimony in the record at page 480, where he said, I never gave her any assignments that she failed to fulfill or that she failed to comply with. Her assignment was to be his legislative liaison. Her job was to work for him as president of the Florida Sheriff's Association when session came in. Her job was to get ready for that. She wasn't doing anything in Okaloosa County at the time because it was a big...
But what about his efforts to hide her status, her employment status in Okaloosa County?
Your Honor, I think that it's totally improper to imply or infer that she's aware of his criminal behavior.
Okay, so your argument is she wasn't aware that he was keeping her essentially, or as the state refers to her, as a shadow employee.
Correct. That's totally unfair to impose what he's thinking and what he's doing behind closed doors. She also wasn't aware of his kickback scheme, but the state chose to try her and convict her by association. And instead of focusing on an intent to steal, they turned this into a scarlet letter trial. And all of their evidence in their brief focuses on giddy conversations with the sheriff, sharing a lobster dinner, dancing with an Elvis impersonator, where if you really look at the picture, you see several women from the sheriff's department were up on stage with the Elvis impersonator. It is a complete distortion, and it's totally impermissible to allow the state to convict her based on what the...
Excuse me then, let me ask you this question this way. What is the most negative evidence that we have that she knew about? Viewing the evidence in the light most favorable to the state. I know I'm...
And with that in mind, Judge, if you could explain to me, Mr. LaBeouf, there's evidence that she told Morris at their December meeting that she needed $8,400 to pay off the lease. There further was evidence that he had a check cut for far more than that to pay precisely that amount, not some general moving amount, but the precise amount she needed. I further believe the testimony was that she had already been told, Mr. Heidel testified, that she had told her by December 9th and then with a follow-up email on December 10th before she ever met with Sheriff Morris that in fact she would not have to pay that $8,400. How is that evidence not inconsistent with a reasonable hypothesis of innocence that she just got a general bonus that she thought she was entitled to when the evidence was that she told, and Sheriff Morris, by the way, testified that he would not have given her that money had he known she wasn't obligated to pay the $8,400, I believe the testimony was.
Thank you, Your Honor. And as you've noticed, that my first argument dealt with her salary and the benefits associated with her salary. My second argument goes to the $40,000 with regard to the $8,400. I think that the defendant was not allowed to fully develop and explore her hypothesis of innocence with regard to that, and that would justify a new trial on that. I think, though, there was conflicting evidence which would justify the courts not granting an acquittal, a judgment of acquittal on that account. She should get a new trial on count 2, but not a judgment of acquittal. There should be a judgment of acquittal on counts 1, 4, 5, and 6, and on count 3, because the state did not prove the intent to steal on those counts, and they denied her the opportunity to put forth the evidence and argument regarding her lack of intent to steal. I'd like to reserve the rest of my time.
May it please the Court, Joshua Heller on behalf of the State of Florida. I think that where we need to begin is what the State's theory in this case actually was. The State's theory in this case was that the defendant's employment with the Sheriff's Office was a sham. And she knew that her employment was a sham. In essence, the state's position is that the defendant was not an employee of the sheriff's office, which she knew. Therefore, by actively participating in the sham in which the sheriff embezzled county funds and property and provided them to her as gifts that he gave her as his mistress, the defendant was a principal to the sheriff's embezzlement. Now, Judge Thomas, I think I gave you accidentally a bit of a promotion there. I want to address the question that you had as far as what testimony establishes that she did not work for the sheriff's office. At 1150 to 1151 of the trial transcript, Ed Spooner testifies that the defendant told her that she no longer worked at the Okaloosa County Sheriff's Office in February of 2009. This was before he became interim sheriff. Talk about picking the wrong person. But additionally, as to the question of working at FSA, and it's been a moving target exactly what her duties are, or what job it was that she had, but counsel appears to assert that she was working for FSA as a lobbyist. I refer the court specifically to 982 and 983 of the transcript, as well as 987 and 1065 and 1080 of the transcript. The defendant never applied to FSA. She was never paid by FSA. She never worked at FSA.
But isn't that, I mean, there was testimony that people donate their time, and in fact, judges donate their time to the Supreme Court, and they come up from different parts of the state. They hang out with Oscar. They live in the basement of the Supreme Court building with Oscar. They drink Oscar's coffee, but they're never on Oscar's payroll. They don't fill out an application. They come up and they present the
But she was on a payroll, Judge. This particular circumstance, she is claiming that she worked as a lobbyist for FSA, that her plan was that she was going to work with Mr. Messersmith. Mr. Messersmith testified that she never worked with him as an FSA lobbyist, and she never worked for FSA on behalf of the Okaloosa County Sheriff's Office. That is specifically stated in those pages of the transcript. So yes, the state presented evidence that was contrary to that. As far as her other duty with regards to being the Assistant Director of Support Services, which was the job that her secret employment application, or personnel application actually provided her, the Support Services personnel testified that apparently people she was supposed to be supervising as the Assistant Director never knew she was employed there, never knew there was Assistant Director of Support Services. Now, I think that it's important to remember that the issue of whether or not she did any work is not the conclusion. The conclusion that the state was seeking to draw in this case is that she wasn't an employee, that this was a sham. The fact that she did no work, according to page 535 of the transcript, demonstrates that. The fact that she told Ed Spooner that she didn't work there demonstrates that.
I thought Mr. Spooner was unable, or Sheriff Spooner was unable to say exactly when that conversation took place.
He couldn't say the exact date. He said it was in February of 2009.
He did, because I thought it was a little more vague than that, because I thought that, it could have been, when I was looking through it, I thought, okay, maybe she told him that in December, when in fact she was on terminal or severance pay. She was still getting paid, but she wasn't working for the Sheriff's Department.
Judge Oxley, that's not the only basis upon which to indicate that she knows that she's not actually an employee. In this case, when she was terminated from the Okaloosa County Sheriff's Office, which is all of the preliminary stuff, let's make clear, is not part of the information. But when she was told that when she was fired, she hugged employees goodbye. She said goodbye to a number of employees that she worked with. She sent out an email to 90 of her colleagues saying that she had separated from the Okaloosa County Sheriff's Office. And then in December, when she gets that job back that she wants, or that she's claiming is legitimate, how many people does she tell? No one, according to the record.
Didn't she go to the conferences? She didn't hide her status, did she? I mean, she appeared at the conferences and...
And Your Honor, I'm sorry.
I think there's some evidence to show that he hired her as an employee. Maybe it was an unorthodox arrangement, but they go to two conferences together. She goes to a meeting in the governor's office.
She goes to a meeting at the governor's office in Tallahassee and says absolutely nothing and sits behind the sheriff. She goes to conferences where they...
I don't think that's evidence that
but it's
she's committing theft. I mean, she's engaging in official duties. Granted, going to conferences, perhaps enjoying yourself. I mean, there are all kind of nuances you can apply to that, but it's not a hidden secret arrangement.
Actually,
in that sense.
Actually, with all due respect, Judge Thomas, it is a hidden secret arrangement. Although she appears at these conferences where she's supposed to be helping FSA, according to Renee Stockton, who worked those conferences, she did nothing for FSA. And she then...
No, I think you're maybe missing my questioning, which is she's at these conferences. One of them, she sort of takes the role of the sheriff's wife in a sense by introducing somebody and doing the introductory
to the Weiss
duties
conference.
at the Weiss conference. I mean, nobody's trying to make an argument, I don't think, certainly not the appellant, that she was suitable to be the employee of the year. But the question is, was it a criminal theft to engage in that employment relationship?
The jury could certainly conclude from the evidence presented, taken in the light most favorable to the state, that she was not an employee, that those appearances at that conference were opportunities to spend time with her boyfriend. That instead
to appear in public and make an introduction as an employee, you're not holding yourself, you're not hiding, you're not being told, listen, I'm putting you on the payroll. There's no evidence, right, that there's any evidence that, hey, I'm putting you on the payroll, but it's a big secret. We're not going to tell anybody. This is a sham, and I know reasonable inferences are drawn in your favor. So don't show yourself. Don't go to any meetings. We don't want anybody to know about it.
And when Investigator Gay asked questions about that, Your Honor, when he went and looked to see, well, okay, she's at this conference. Is she a law enforcement? Does she work for us? She found that in the public portion of the Okaloosa County Sheriff, there was nothing. However, the private portion, the portion that nobody could see, had her hidden in that as a law enforcement officer. And then when he asked questions about that, when he started discussing that, Mike Coop and then the sheriff showed up in his office and, I think as he stated, made abundantly clear that he needed to keep that quiet. So...
But that was the sheriff. I mean, because she gets a fuel card, which I guess the sheriff's deputies got. She gets assigned a unique PIN number.
No, it's not a unique PIN number, Your Honor. It is the sheriff's PIN number. She was given the fuel card, a copy of the sheriff's fuel card for both of those, so that it would appear when she was using that fuel card that it was the sheriff who was getting that fuel, not her. So...
But the woman that issued the card certainly knew, and the person that took the car to her certainly knew, because my understanding of the testimony was that not that Sheriff Morris delivered the gas card, not that Sheriff Morris delivered the car. I thought all of those things were done by other individuals. So it's not as if nobody in Okaloosa County knew that she had been hired back, correct?
The testimony was that only those employees that needed to know knew of this arrangement.
What's the evidence that she knew that only those that needed to know? Or what reasonable inference from what evidence could we infer that only that she knew? Because again, as Judge Hawks just suggested, it's not what Sheriff Morris knew, it's what she knew.
Correct, whether or not she knew that her employment relationship was a sham. And I think that you need to look at, first, the fact that she told Ed Spooner that. Now, I will feel free to go back and take a look, but my recollection is that that was February of 2009. Additionally, I think that you also need to look at the fact that despite the fact that she had separated from she even called her rent to cancel her lease, so she knew that she had been terminated. She told all these people that she had been terminated. Yet when she is rehired, none of that.
So if she sent out an email saying, I'm back, then you wouldn't have had a case. You wouldn't have brought it. Everything else would have been fine. It was just that one email.
No, Your Honor. I'm saying that when you look at the circumstances altogether, that the jury had evidence which contradicts the assertion that is being made that, well, she didn't know about this arrangement.
It just seems like we're trying to take what Sheriff Morris may have intended to do or what he thought may have been desirable for whatever helped him in his goal. I mean, I think that there was some evidence that she felt that he wanted to expand their romantic relationship, and she did not. She wanted a more professional relationship.
I believe that was the defendant's testimony.
Right, and she also...
In a JOA case, I don't think that relying on the defendant's testimony establishes that. I think that, with all due respect, I didn't mean to interrupt your
No, that's all right. But, you know, and See, now you distracted me, so I don't remember the rest of it.
I think that well, and now I don't remember the rest of my answer, so I guess we're in a little bit of trouble here. I think that, again, taking the facts, viewed in the light most favorable to the state, what you have is you have a embezzlement circumstance where the sheriff has provided property within his trust that he is converting to personal use to provide her with as gifts. That's why all of these other gifts are important. This is the nature of the relationship. These are gifts to a mistress. This is not an employee. That is the issue that the jury is presented with, and from which the facts on this record provide the jury sufficient evidence for the jury to consider that question.
Why couldn't he have done everything he did without the guns? I mean, I don't know what the purpose the guns play if, in fact, she has no right.
I don't understand.
Well, I mean,
you said
she was issued Santa Rosa County.
No, I'm sorry. You said he. I don't understand. You're
Sheriff
referring
Morris,
to the sheriff. Okay,
or his department, whoever issued her the guns. She is, in fact, introduced, as Judge Thomas says. Frank Messersmith knew that she was going to help him. Frank Messersmith said it's not uncommon for Sheriff's Department to send sworn deputies to Tallahassee to assist at their uniform and their actual experience, and they come from the hometown. I mean, obviously, Mr. Messersmith thought that this was beneficial and not completely uncommon. And so she thought that she was going to play this role for the sheriff, and maybe she did think that she had a good job, but just does a good job mean that it's – and maybe the sheriff thought, I'm going to treat her so well that eventually the romantic relationship I want will come about.
No, Your Honor. First of all, let me address the Messersmith issue. Mr. Messersmith indicated that never happened, that he indicated that he would be willing for her to do things, but she never did them.
Well, I mean, but the session starts in March. When was the sheriff arrested? I mean,
he was arrested. I believe we put in brief that it was a few days before the legislative session began. But that's, again, if she's preparing for the session, he said she would work with him. She's never worked with him. He indicated she never worked with him. She was never an employee of FSA. She was never an employee of the Okaloosa County Sheriff's Office that worked with FSA. That's what the testimony in the record is. The jury can credit that testimony and determine that this employment, which is now apparently that she is the FSA lobbyist, not that she's the Assistant Director of Support Services, or then promoted to the Chief of Staff of Okaloosa County Sheriff's Office despite not living or working there, the jury can conclude that that's just not true on these records. They can credit that testimony and reject that. That's why this is properly submitted to the jury. So, so in the absence of any additional questions, the state respectfully requests you affirm.
Your Honors, the first thing the state came up and told you was that they could justify this conviction because the defendant was a principal. And that's what they've been trying to do all along, is to take the bad acts and the criminal intent and the devious nature of the sheriff and infer that on the defendant. But if you go to the specific instruction on principle, which was read in this case, it requires a conscious intent that the criminal act be done. And the state must prove that the defendant encouraged the other person to commit the crime. The evidence doesn't support that in this case. The evidence does not support that the defendant, Ms. Thornton, knew that the sheriff was stealing from the state by taking illegal kickbacks, that he was using the illegal kickbacks to pay her the money that he paid on count 3. There's no evidence to support that.
It seems like the state's theory here is almost unrelated to the kickback scheme. In other words, I meant to ask this before the state sat down, but it seems to me that if we write an opinion affirming in this case, the opinion will hold that if a state employer hires somebody, whether they're taking kickbacks to pay their salary or genuinely paying it out of the public fisc, and they say, listen, don't do anything for a couple months. The job's really going to heat up in July, but for now you don't need to do any work. That's theft.
That's
regardless of the source of the income.
That's exactly right. That's exactly right. And when they brought up the argument of embezzlement, they said, oh, we don't have to prove criminal intent in embezzlement, and they cite the Siegel case. The Siegel case totally supports us, because in Siegel, there was a student who had a right to a computer, and then they said, you don't have a right to the computer, you're losing your position with student government, give it back. He said, no, I'm going to keep it. Sheriff Spooner's unrefuted testimony in this case was when he told Ms. Thornton, look, the sheriff's been arrested, he's no longer president of FSA, your position's no longer needed, a bunch of other people's positions are no longer needed, please give back your car, the gas card, your gun, the phone. She said, fine. It was undisputed that she did that. There's no embezzlement here. But they charged from the very beginning that she stole it from the very day that she got rehired. There's no evidence to support that, and her reasonable hypothesis of innocence was not rebutted. Thank you.
Thank you. Again, I would invite everyone to join us for coffee on the 3rd floor. Both the stairs and the elevator will be on your right as you exit, and we'll be in the rotunda on the 3rd floor. Thank you.